Hello everyone, welcome back to RR Corporates. We have two channels, RR Corporates and RR Legal Talks. Now we are going to discuss on the important topic, the jurisdiction of NCLT under Section 60, subsection 5 of the Insolvency and Bankruptcy Code 2016. Can the National Company Law Tribunal decide every single dispute related to insolvency? Or is its power not so absolute? Welcome to the channel. Today's video we will explore a fascinating intersection of insolvency law and judicial interpretation. Especially, we'll analyze the scope and limits of Section 60, subsection 5 of the Insolvency and Bankruptcy Code 2016, a provision that once seems to grant Thanos-like powers to the NCLT. So we'll break down the major Supreme Court rulings like Gujarat, Urja, Vikas, Nigam versus Amit, Gupta, and Alok, Kaushik versus Bhuvaneshwari, Ramanathan, Tata Consultancy Services versus Vishal, Ghisulal, Jain, and see how the judiciary is reading the boundaries of NCLT jurisdiction. We'll break down these major Supreme Court rulings. Section 60, what Section 60 says? Section 60, subsection 5 reads, any application or proceedings by or against the corporate debtor or corporate person. If we see clause A, any application or proceeding by or against the corporate debtor or corporate person. B, any claim made by or against the corporate debtor or corporate person, including the claims by or against any of its subsidiaries situated in India. C, any question of priorities or any question of law or any facts arising out of or in relation to the insolvency, resolution, or liquidation proceedings. This is what the Section 60, subsection 5 says. So these are all non-obstant provisions. So meaning they override any other law. So what is the intent of lawmaker? Centralize insolvency related litigation and avoid forum multiplicity. So now we'll see the practical operation, how NCLT uses Section 60, subsection 5. Let's take few examples from NCLT rulings. Classification of creditor claims, COC disputes, allegations of extortionate transactions. In classification of creditor claims, if RP treats a financial creditor as an operational creditor, the matter goes before NCLT under Section 60, subsection 5. COC disputes, inclusion or exclusion of a creditor from COC can be challenged here. Allegations of extortionate transactions. NCLT has entertained such matters even without an application under Section 51. The quote is, the resolution professional is not vested with the adjudicatory powers. All actions taken by him are subject to control of the adjudicating authority. So these instances show a broad use of Section 60, subsection 5, especially A to C, A and C, to resolve complex stakeholder disputes during the CIRP. Now we will see the case studies. 3 case studies we will discuss. 1, Gujarat, Urja, Vikas, Nigam Limited versus Amit, Gupta. The background of the case, the power purchase agreement between a corporate debtor and Gujarat Urja. Agreement had a termination clause triggered by insolvency. Now the issue, could the termination be stayed by NCLT under Section 60, subsection 5C? Supreme Court held, yes, because the termination was solely on the ground of the insolvency, And Section 238 of IBC overrides any contract to the contrary. But court cautioned NCLT and NCLT, do not usurp the jurisdiction of other courts. Jurisdiction under Section 60, subsection 5C exists only if the dispute arises solely from or relates to insolvency. So the key learning here is NCLT can't deal with all disputes. The nexus with insolvency must be clear. We'll go to another case. Alok Kaushik versus Bhuvaneshwari Ramanathan. The facts of the case was the registered valuer wasn't paid after his appointment was cancelled post CIRP qualification. He claimed professional fee under Section 60 subsection 5. Supreme Court held, even though the CIRP was satisfied, the services to the CIRP. Thus, the issue falls under Section 60 subsection 5C as an incident of the CIRP. So the importance here is this case broaden the definition of what arises out of CIRP means. Professionals can rely on Section 60 subsection 5 for legitimate CIRP linked claims. We'll go to another case, TCS versus Vishal Jain. The facts: TCS terminated a contract due to alleged breaches by the corporate debtor. RP challenged the termination before NCLT. Supreme Court held the contract was terminated due to the past breaches, not insolvency. So therefore, no jurisdiction under Section 60 subsection 5C. Dispute arose outside the CIRP. So the consequence, RP must approach the court or arbitral forum. NCLT's jurisdiction is not a catch all, especially for general commercial disputes. So NCLT jurisdiction is not a catch at all. So this is not a catch all, especially for general commercial disputes. This is not the consequence. So the analysis, you see, Section 65A versus C. Supreme Court has focused heavily on 60 subsection 5C, the residuary clause. But what about 65A, which gives jurisdiction over any application or proceeding by or against the corporate entity? So some of the disputes like service defaults, pending payments may still fall under Section 60 subsection 5A. Even ArcelorMittal India versus Satish Kumar Gupta clarified the NCLT alone has a jurisdiction when it comes to the applications and proceedings by or against the corporate that are covered by the code. So the question is, the dispute part of the insolvency process or an independent civil matter? This is the question. So the conclusion, the path ahead, Section 60 subsection 5 was designed to centralize all insolvency linked disputes under NCLT. But recent NCLT rulings have rightly drawn boundaries to avoid forum shopping, but also created, so there is some ambiguity because of the focusing on 60 subsection 5C. So potentially weakening the power of, it may weaken the power of Section 65A and 65B. So as a professionals, RPs, creditors and litigants carefully evaluate what is the nature of the dispute. Does it stem from insolvency or is it contract based? Which clause of Section 60 subsection 5 applies, whether A, clause B or clause C? So until there is a further legislative clarity or a constitutional bench ruling, the interpretation of Section 60 subsection 5 agreement dynamic and contextual. If you found this video helpful, please like, share and share with your peers. We have two channels, RR Corporates. Please do subscribe. and other channel RR Legal Talks. Please do subscribe for more latest updates. Thank you.